Good afternoon, everyone. My name is Wendy Thomson, and I'm one of the partners within the insurance team, and I'm also a solicitor advocate. I head up our disease team and deal with a wide range of disease cases, as well as lots of other types of personal injuries action. I shall be presenting the second part of today's seminar. My colleague Jennifer Stewart, Senior Associate, will be presenting the first part of the seminar. Jenny, I think it's fair to say, is our most experienced occupational illness solicitor within the firm. She has been working pretty much solely in disease cases for over 20 years now, and she initially represented pursuers and then came over to the dark side to join us. She's well placed to give advice about a wide variety of claims. So we're going to cover a list of things which is appearing on the screen now. I won't read them out to you. You can all have a look and see what we're going to cover. There's a bit to get through. Can't see it's going to be a laugh a minute. It's quite dry, unfortunately. So hopefully, however, you'll all find at least aspects of it interesting. And I'll just hand over to Jenny now. Thank you.
Okay, thanks very much, Wendy. The first thing I wanted to look at today was the assessment of damages on a provisional damages basis. Typically in Scotland, we're dealing with these primarily for pleuroplex cases, and I think it's quite settled the position in relation to those cases and quantum. There's a case of Wales against the Advocate General from 2015, which established the range of awards, which is dependent on various factors, including age of the pursuer, existing comorbidities, and impact on life expectancy, as well as, of course, their level of anxiety and worry at developing a more serious asbestos condition. But this case, although it is an English decision, is quite useful in seeing how a court may approach the assessment of quantum in an asbestosis case. And it is one that, not unsurprisingly, pursuers agents have leapt upon as being a great case for them when valuing these cases, particularly because it's to a fairly low level of disability. And I have seen certainly reliance placed on this, and there, as I said, the valuations going up as a result of it. So the case concerned a 74-year-old who was employed between 1968 and 81 as an electrician. Liability had been admitted, and his evidence of his breathlessness had been accepted by the court, so only dispute therefore is in relation to the quantum of damages. His medical expert assessed him as having a 10% disability, which was said to be sufficient to cause breathlessness on prolonged or strenuous exertion, and had also been responsible for an ongoing reduction in his activities of daily living. It was estimated he would develop a further 5% additional respiratory disability and potentially up to 10% over the course of his lifetime. And it was also assessed that he would have a 5% risk of developing a more severe and rapidly progressing asbestosis, which could impact on his life expectancy. Over and above that, you had a 3% risk of developing mesothelioma and also a 3% risk of developing lung cancer. So the judge looked at the JC guidelines, and the relevant section here is Chapter 6C for asbestos-related disease. The upper bracket is where disability is in excess of 10%, and that's causing progressive symptoms of breathlessness by reducing lung function. Awards will be towards the lower end of the bracket, where the condition is relatively stable, and if the condition is likely to progress, as was the case here, or has progressed to cause more severe breathlessness, the awards are going to be towards the higher end. I think it's accepted that it is a wide bracket, and ultimately it's the extent of respiratory disability that the claimant will have that will determine where in the range of awards the case will fall. For this upper bracket, from 10% disability upwards, the range is £32,780 up to £90,300. And the lower range, where the respiratory disability is assessed as being between 1 and 10%, then the range would fall between £12,860 and £30,630, so not an insignificant sum of money. It was also accepted here that the level of award would depend on whether it was provisional or full and final, and also in relation to the extent of any anxiety of the particular individual. It would have to be, or it followed that an award for provisional damages would have to be lower than that for full and final damages, given once somebody settles on a provisional basis, they have the right to return to court at a later date for further damages if they develop a more serious condition. So effectively, when assessing provisional damages, they're being compensated for the condition they have at this stage, and it's not looking to see what potentially they might have in the future and giving them a little bit extra money for that. So the approach the defendant took here was to say that damages should be assessed on a full and final basis, and then a deduction would be taken by the expected risk.
Yeah, I think it's what we expect anyways. Yes, and that's stuff we didn't get.
Oh, hello, sorry, I'm not sure if somebody needs to mute themselves. Thank you, sorry about that. Yeah, sorry, so the defendant wanted to value damages on a full and final basis and then take the percentage risk of developing a future condition and deduct that. So, for example, if the full value for mesothelioma was £95,000 and there's a 3% risk of the person developing that, that would result in a £2,850 reduction. Now, this approach was favoured by the judge, but he also did consider how the JC guidelines dealt with both provisional damages as well as full and final awards, and at the same time the percentage disability the claimant had. He ultimately found that the diagnosis in this case fell around the borderline of the two brackets within the guidelines, but since the lower bracket was suggesting awards from 1 to 10% disability and the upper bracket was in excess of 10%, he felt the lower bracket should apply in this case, where he accepted that the level of disability the claimant had at this stage was 10%. He then went on to consider whereabouts in that bracket the claimant would fall, on the basis that generally it's accepted that somebody, a younger person who gets the condition, would normally receive a higher award. No evidence of particular anxiety was given for the claimant, but the judge considered that his symptoms were worse on his evidence when he was gardening, and he felt that that would mean he was towards the higher end of the lower bracket and awarded a figure of 35,000 on a full and final basis. He then adjusted that to account for it was being a provisional award, and using the arithmetical approach, it was agreed that he would reduce the sum by £5,000 to £30,000. So that's just under the lower limit of the bracket. However, the judge felt that this was still too low and ultimately decided that the correct figure in the circumstances of this case was £32,000. So although it can be assumed that an arithmetical approach will be taken by the court when assessing provisional damages, still, of course, it's for the judge to decide the exact level of award. But this is a useful case going forward in establishing where the 10% disability for asbestosis, or indeed diffuse pleural thickening, would lie, given there's a slight overlap of the lower and upper brackets. I think in my experience, most of the cases coming through are rarely in excess of 10%. So it is a very useful case when looking to quantify asbestosis claims. Now, I'm going to move on to assessment of lost years, and I have included this case because I find it a very interesting case. However, it probably is a topic in its own right, and so I think it would take far too long to go through it properly. The slides are in there, and I've kept them in case anybody would like to go away and have a read of the judgment. It's a very useful example for practitioners on how to quantify a lost years claim for a successful business person who's still working at the time of contracting a fatal illness. At first instance, the claimant had been awarded damages of 175,000 in relation to pain and suffering and various other things, but had not been given an award in respect of lost years. Now, he had founded a business and profits from that were in excess of £4 million a year, so you can imagine that the claim for loss of earnings was a pretty substantial one. However, it was held at first instance that he was not entitled to that, and leave to appeal was sought by the claimant and denied until his solicitors tried again, and under an exception in the civil procedure rules, the Court of Appeal overturned the loss of earnings element and ordered a reassessment of that. The the reassessment when that came through, when that decision was handed down, increased damages to 2.62 million. So quite a substantial difference from the award made at first instance. It shows the correct legal approach in this case to be taken to claiming income that would have been received but for life expectancy being cut short. And as I say, it goes through in quite a lot of detail how you would look at dealing with a claim like this. So it is a very interesting read. I think I got a little bit carried away with the slides for this one, because in reality, as I said, it is one that's probably merits a seminar all of its own. So I'll leave those slides there for you to look at your leisure later. Next case I wanted to discuss is Bernard Jackman against Harold Firth and Son from 2021. I feel this is quite an interesting case because particularly those of you who deal with asbestos claims will be aware that it's very rare that we have a great deal of evidence to be able to assess the allegations being made by the family of the deceased. There's very often no witness statement from the deceased, and even if there is one, it really doesn't go into the sufficient detail that you would need to be able to properly assess the claim. This was a mesothelioma claim, and the main issue here was whether the deceased had been employed by the defendant, Harold Firth, at ICI in Huddersfield. It was accepted by the defendant that if employment was accepted, then liability would likely follow. So here there was a situation where there was no statement of the deceased. There were HMRC records which showed that the deceased had started to work for the defendant at some point between April 68 and April 69, and then had left at some point between April 1972 and April 1973. There were also medical records that relied on by the claimant, which included, probably quite crucially for them, a letter from the date of the deceased diagnosis recording that he worked in the construction industry and also worked with asbestos pipes in the 1970s at ICI. Evidence was led from the deceased widow, and that really went to the central issue of whether or not he had been employed by the defendant. She was able to recall that her husband had worked for the defendant at ICI in Huddersfield, that he didn't like the work and talked about Eddie Firth, who was his boss, for ages afterwards. She also recalled that when he was given his diagnosis, he told her that he would have been exposed whilst cleaning out pipes at ICI. The judge also was given witness statements from two former employees of ICI who unfortunately had died and were obviously unable to give evidence of proof, but the judge was able to read those witness statements and he agreed that their evidence could be relied upon in the proceedings. Their statements describe the general working conditions at the relevant time that the deceased had been there, and the judge held that there was a clear impression from each of those statements that over a long period, and at least covering the period that the deceased would have been working there, that labourers, laggers and maintenance engineers working at the ICI plant were exposed to asbestos fibres. He then went on to look at the proper approach to witness evidence and assessing that. So he reminded himself of the principles in the case of Bannister against Freeman from 2020. Was first of all noting that a strong recollection of events expressed in evidence with confidence is not a reliable guide to the accuracy of the recollection. Secondly, the fact that a witness has a considerable amount to gain if his or her recollection of events is accepted by the court as fact means that the witness's recollection is very likely to be biased towards that which supports the outcome he or she seeks. Thirdly, when a witness recalls evidence from the past, he or she is in fact unconsciously reconstructing those events. And also that testing recollection against contemporaneous documentation is a very useful and important exercise. He also reminded himself that he was not allowed the tragedy inherent in every mesothelioma case and the natural desire to assist in any proper way to lead to a lax approach to fact finding. So he went on to analyse the widow's evidence in 3 chronological parts. First of all, her recollection of events post-2016 and the conversation she had with her husband following diagnosis and up to his death. Her recollection of conversations from 1968 to 1973 when he was working for the defendant, and her general recollection of matters after 1973, which was generally her husband complaining about the defendant and the unpleasant and horrible job that he had to do for him. The second part of her evidence was treated with some caution, as the judge found that her recollection of events would have been triggered by what her husband had said to her after his diagnosis. But he was impressed by the last part of her evidence, and he was particularly struck by the widow recalling that her husband would get very annoyed if the name Firth was mentioned, and she'd actually gone out of her way to avoid naming a relative by marriage who had the same name. Over and above that, her evidence was in part supported by the medical notes. So on the basis of the evidence, he came to the clear view that on the balance of probabilities, the deceased had been exposed to asbestos fibres whilst working at ICI for the defendant, and obviously then had no difficulty in finding that the defendant was in breach of duty owed to the deceased and that the breach caused him to suffer personal injury. So I think this is a helpful reminder that witness evidence must be looked at in context and as part of the entire evidential picture. It does include looking at contemporaneous evidence such as GP records, hospital records, and also we find particularly useful are DWP records if any application has been made for benefits, as that can sometimes be a source of other exposure that's not been sued for. The other issue to be taken into account is the fact that in this case, the defendant didn't produce any evidence of its own to counter the allegations being made. And so overall, I think the evidence of a single detailed and careful witness, which is consistent with documentary evidence, even if there's no other live evidence, should be sufficient for a claimant to establish key facts on the balance of probabilities. And so that it's not always going to be to their detriment that they don't have any direct evidence from the deceased. This is a case that was decided in September this year, so it's fairly recent Scottish case. As everybody aware, a 3-year limitation period applies in the majority of injury claims in both Scotland and England, with the courts in both jurisdictions having actual discretion to allow a claim to proceed despite being issued late. This case raises the question of the effect of a period of delay on the part of the claimant, because insurers of somebody who'd exposed them to asbestos could not be identified. You'll know that it's never going to be possible for any lawyer to give a definitive answer to the question of whether or not a claim will be allowed to proceed, although time barred, because each case requires to be assessed on its particular circumstances, and ultimately, of course, it's up to the discretion of the court. But this does give some further guidance. Here, the pursuer originally was diagnosed with plaques in 2007. He went to solicitors with a view to making claims against 2 of his former employers, Hart Builders, Edinburgh Limited and Duncan Anderson Limited. After quite a period of time in February 2010, proceedings were eventually raised against Hart Builders only, as employers' liability insurance was known, but not against Duncan Anderson, whose employers' liability insurers had not been traced by the pursuer's solicitors. Now, unfortunately, this case got caught up with the whole plural plaques litigation, and ultimately the case didn't actually settle until April 2017. But it did settle at that point on a full and final basis, and that included a 25% deduction for the exposure with Duncan Anderson, who hadn't been included in the original action. What then happened is the pursuer was diagnosed with pleural thickening, and he consulted a different firm of solicitors. In 2019, he was told he couldn't pursue Heart Builders because he had obviously settled his claim against them on a full and final basis. His new solicitors found insurers for Duncan Anderson, which the previous solicitors had not been able to find. And they had been able to do that with checking with the Employers Liability Tracing Office, or ELTO, which had been set up in 2011 and hadn't been available at the time he'd first consulted his solicitors in 2007. His new solicitors also had to restore the company to the register because it had been struck off in January 2014, and they were then able to raise the action against Duncan Anderson. So the sheriff did hear evidence from a solicitor who originally dealt with the action, or from the firm that originally dealt with the action, and her position in evidence was that her firm's conduct in the first action was appropriate, and that was accepted by the sheriff because there was no evidence before the court that it was inappropriate. She also accepted that that the pursuer's new solicitors also accepted that the action was time barred. However, the sheriff focused on the original solicitor's deliberate, reasoned and rational decision not to pursue Anderson when insurance was not identified as being effectively an abandonment of the claim, and that the court's discretion and discipline limitation should not be used in those circumstances. It was never intended for that purpose. Anderson should have been included in the original action, although the company was in voluntary liquidation at the time, but it hadn't at that point been struck off the register of companies, and therefore could have been included in the action and decree taken against them at that time, which would have allowed, if insurance was subsequently found, the original pursuer solicitors to then take further proceedings. So in all of the circumstances, the sheriff held it would not be equitable to allow the action to continue. And I think that whilst it might seem harsh on a claimant who could be put to the expense of pursuing an insolvent defender without the prospect of recovering any damages, my view is this is a welcome decision for defenders, because if the claim had been allowed, it would have had the effect of allowing other claims if insurers are subsequently traced or additional information put onto the ELTO website. If, for example, an insurer had disposed of relevant papers during the delay on the part of the claimant, this would be unlikely to be factored in for these purposes, as it would be prejudice to the insurer rather than the defender or defendant itself. And I cannot see actually that it's right that the insurance situation is to be taken into account for these purposes in favour of the claimant. The issue of limitation is an ongoing thing that's been looked at by the Scottish Law Commission, and we may well see further changes to limitation in disease cases going forward, but this is quite an interesting recent case to be aware of. The next case I wanted to discuss is a hand-arm vibration syndrome case, Stewart Lambert against ProServe UK Limited. This is a couple of years old, but I think it's quite an important one to be aware of, as it's the first hand-arm vibration claim to come before a Scottish court in over 10 years. I think it's a decision to be welcomed, as it confirms that it's not sufficient for a pursuer simply to prove that there has been some power tool usage, and that they've also developed halves-like symptoms to succeed in their claim. Here, basic elements of the claim were left unproven, impacting on all aspects of the case and ultimately making it impossible for the sheriff to find in favour of the pursuer. The defender had argued that the pursuer had not provided any evidence of the levels of vibration he'd been exposed to, and therefore he had not proved that any breach had caused his condition or that there was a breach of duty owed to him. The pursuer here gave evidence, as did a colleague. Unfortunately, they contradicted each other. And also, unfortunately for the pursuer, his reliability and credibility were questioned, and his colleague was preferred over him. Over and above that, neither of them gave evidence of the particular tools used, and therefore there was no evidence of the potential levels of vibration transmitted when using them. They couldn't prove whether the exposure action value or the exposure limit value, as defined by the Control of Vibration at Work Regulations 2005, had been reached or exceeded. The pursuer did try to argue that as a defender had never mentioned employee exposure to vibration, that a negative inference could be drawn from that. However, the court disagreed, as the onus of proof was on the pursuer and not the defender to establish the vibration produced by the tools in question, which is quite a critical ruling, as it means that it meant the court was not able to find that the pursuer was actually suffering from hand-arm vibration syndrome, and so found in the defender's favour. However, the court did go on to consider whether, if halves had been proved, the defender was in breach of duty and whether that breach caused the duty. And the court did find that the failure to prove that the exposure action value was likely to be exceeded did not excuse the defender from compliance with the 2005 regulations. They were required to carry out risk assessments in terms of those regulations, and they had failed to do so. If they had carried those out, it may have flagged up further proactive measures for them to take. It also had an impact on causation, as with no evidence as to exposure levels, it was impossible for the pursuer to prove that the risk assessment would have triggered the need for further steps to be taken, which in turn would have prevented the development of his condition. There had been some suggestion in this case, or the judgment was first handed down, that it may lead to a decline in these cases being raised. However, I think, and Wendy will come on to talk about QOCS later, I think now in the advent of QOCS, I think that seems unlikely. I think, though, that pursuers will now need to ensure they're able to prove all aspects of their case, including vibration levels, to be sure that they're going to be successful. Unlike many other industrial diseases, halves can be caused by other things. And so I think the magnitude of vibration and the levels of that is critical to the success of a claim, and that is now, is reinforced by this decision that it is for the pursuer to prove. Although conversely, where a claim has been well prepared and there's evidence of, or uncontroversial evidence of a breach, defenders do obviously need to be in a position to lead some evidence to support a good causation argument and to avoid liability. So it is a helpful case up to a point, but obviously defenders should still be mindful of their duties under the various regulations. So the last thing I'm going to talk about is a deafness case, which again is fairly recent, being from April this year. It's another Scottish case involving a 24-year-old, and it's a case where there's sudden exposure to noise. She was in fact awarded £241,277, and primarily that was as a result of an award in relation to hearing aids that she would require to have over her lifetime. It's also quite interesting because it's not often that deafness cases actually proceed to a hearing. Usually these are very low value and they settle on an economic basis. However, here in 2015, the pursuer, who was a tanning salon assistant, was exposed to noise emissions from a fire alarm, which was known to management to go off without any cause in her workplace for a 4-hour period from 9 AM to 12:55. Nobody knew why the fire alarm had been triggered. And throughout her shift, she was advised by her manager not to leave the store. And it was only midway through the incident that he actually turned up to muffle the noise with tape, and he called an engineer, but he then promptly left. And she was told to stay in situ. The noise was said to be excessively loud, and although after the incident she was not immediately aware of any hearing loss, she did perceive a muffling effect, which she attributed to her tinnitus. She was ultimately diagnosed with bilateral sensorineural hearing loss, and advised that she would need to use hearing aids for the rest of her life. She was actually, in addition to being a tanning salon assistant, she was a college student studying dance, and because of that, it was held that she would need to buy replacement hearing models because standard NHS ones would not stay in her ears. So proceedings were raised, and this was after the Enterprise and Regulatory Reform Act. So it was alleged the defender was in breach of its common law duty to take reasonable care for her safety and not to expose her to unnecessarily risk of injury, as informed by the Control of Noise at Work Regulations 2005. It was argued on behalf of the pursuer that she had been exposed to conditions that more likely than not gave rise to a significant and reasonably foreseeable risk of injury, and that the history and development of her symptoms were consistent with there being a causal link between the noise exposure and the damage sustained. Her acoustic expert assessed the average noise level in the salon as being above the lower exposure action value under Regulation 4 of the 2005 regulations, which triggered the defender's duty to take positive steps to assess the risk of injury. They were also satisfied that there was a reasonably foreseeable risk of injury and that Regulations 5, 6 and 7 had been breached. No suitable and sufficient risk assessment was undertaken. No attempt was made to reduce or eliminate the risk from noise, and no personal hearing protectors were afforded. There was also an issue in this case in relation to the medical evidence, which caused the greatest difficulty in establishing a causal link. Experts for both sides noted that in general terms, exposure to noise between 85 decibels across an 8-hour day is unlikely to cause damage to hearing. But it was accepted here that the risk for the present purpose had to be defined by reference to the regulations and the threshold levels there. For this type of one-off exposure, the court held that a daily exposure level calculation was appropriate rather than weekly, and the evidence pointed to her having a daily exposure level of 82.3 decibels, and on that basis, they found the defender had breached the regulations by failing to risk assess and taking any steps to mitigate the risk. Whether this breach actually caused the pursuer's hearing loss was a bone of contention as well. Evidence was led from the pursuer, her flatmate, and her mother, which indicated a contemporaneous onset of tinnitus and hearing loss following the exposure. They were found to be credible witnesses. Using a 3-point diagnostic test, the pursuer's medical expert concluded the loss was noise-induced. But under cross-examination, he required to make some concessions, and it transpired that 2 of the 3 conditions he was relying on to meet this test were not met, including the fact that the noise exposure was not over 85 decibels. Defender's expert concluded that noise was not the cause, but based that on factual assumptions, all of which were challenged by the pursuer's evidence, as well as that of her flatmate and mother. Ultimately, the court found that the pursuer's medical expert evidence was admissible insofar as it had not been contradicted, and that, along with the evidence from the pursuer and her witnesses and the history and onset description, was enough to make the causal link, and the defender was found liable to pay damages. I do know, though, that the decision is currently under appeal given the causation issue, and I think this is one that may go on for quite a while. So certainly it's one to keep an eye out on. And I'll hand you back to Wendy now.
I'm going to start off by discussing some fatal claims, and in particular Section 4.3 awards is something I wanted to address. They were also formerly known as loss of society awards, and obviously I'm aware that most insurers, particularly those of you who work mostly south of the border, are aghast at the amounts that can be awarded for loss of society or Section 4.3 claims in Scotland. And just as a reminder, what these cover are sums for compensation for distress and anxiety endured by the relative in contemplation of the suffering of the deceased before the deceased's death, grief and sorrow of the relative caused by the deceased's death, and the loss of such non-patrimonial benefit as the relative might have been expected to derive from the deceased society and guidance if the deceased had not died. So the landscape of how fatal claims were dealt with changed as a result of the case of Hamilton in 2012, which you're probably familiar with. So basically, that it was confirmed there that the courts required to take into account both judge and jury awards in reaching a decision as to how much both Section 4.3 awards and Solicitor and other awards are worth. And juries from then on were to be given a range of awards for damages. So there were actually quite a few mesothelioma cases which ran shortly after that, and I've listed them there, but I'm not going to go into too much detail. They're the cases of McGee, McCarn and Gallagher, and in each of those, awards of £80,000 for Section 4.3 were made to widows and £35,000 were made to adult children of the deceased. Now, all these deceased had been fairly elderly, but there was a bit of a range in their ages. There was then the case of Manson against Henry Robb, which came after all of those cases. And in that case, £75,000 was awarded to the widow and adult sons were awarded £30,000. And that was despite the fact they were all very close. But I think what the judge, Lord Dewis, was taking into account there was that the loss of life expectancy was only 5.8 years. So these are all mesothelioma cases where Section 4.3 awards were made and how the awards were reached were discussed, and they should all be considered when valuing fatal claims. And obviously they have all inflated in value somewhat now. We've also then got to take into account jury decisions, which were both in accident cases, and the two main ones are Stanger against Erland Flaws from June 2016, where £120,000 was awarded to a widow and £50,000 to adult sons, £20,000 to a grandchild who had a close relationship and £15,000 to the grandchildren who were considered to have more normal relationships. There's also the jury awards in Anderson against Brig Bray from 2015. That one's a bit different though, because the deceased was 33 and the widow who was pregnant at the time was awarded £140,000 for Section 4.3. But these are all awards which any jury or judge are going to consider when reaching a decision on appropriate award in any mesothelioma or lung cancer case, which is obviously what we're focusing on here. Just waiting for the slide again. Yeah. So there are a couple of more recent cases involving fatal awards, but they don't involve disease cases, but obviously they do need to be taken into account when we are valuing these claims now. The first of these was Andrews against Greater Glasgow Health Board in 2019, and that was one more along the lines of the Manson case. The deceased had a life expectancy of 7.5 years, but for the action which caused his death, and his widow was awarded £75,000. So that was probably viewed as pretty stingy on the part of the judge. I think Lord Pentland it was on that occasion. Then this year, we've had the case of MacArthur against Timberbush Tours, and that's obviously quite different from most of the mesothelioma cases and lung cancer cases that we get, because the deceased in that case was only 26. His parents were awarded £100,000 each. His stepfather was awarded £70,000 and the half-sister £45,000. I think that one's quite interesting from the point of view of the stepfather and the level of award that was granted there. We do often see cases involving siblings, step children and step parents. So and they are entitled to be awarded awards potentially at the same level as the natural parents. But I think it can be seen how it was appropriate for that stepfather to be awarded less than the natural parents in that case. And the award for the sister was also fairly generous. So these are useful cases to be aware of and required to be taken into account. However, I thought it would be useful to let you know that sort of range of settlement figures that we tend to see in mesothelioma and lung cancer cases. And this is obviously bearing in mind that in the majority of these cases, the deceased are fairly elderly. The youngest tend to be in their 60s, but many tend to be in their late 70s or 80s. So the ranges that we tend to see for widows for section 4.3, and it is usually widows rather than widowers, is £75,000, maybe up to £90,000, depending on the age of the deceased and the widow and the length of the loss of life expectancy. And that is quite important, the length of the loss of life expectancy. For children, usually the least you can get off with is usually about 27,500, unless there's any suggestion that they really didn't have a relationship, in which case their arguments can be made for a lower amount, and certainly up to £35,000. And again, the same factors required to be taken into account. For grandchildren, the range tends to be £8,000 to £15,000, unless they're very young, in which case less would be awarded, or there's a very close relationship, and for instance, they were effectively in the shoes of a parent, in which case a larger award would likely be made or agreed. Siblings, the awards tend to be similar to grandchildren, but can be more, for instance, if they're very close, or as a case recently where the argument by the pursuer was, well, they were the only relative and they were very close, and the sister had done a lot of work for the deceased, so she was awarded slightly more than we might normally have expected to agree to award a sibling. And step relatives as well, they're often awarded slightly less than blood relatives, but it does depend on the relationship. So I thought then I'd move on to COVID claims. Obviously, that's a bit of a hot topic, and people are interested in what might be happening. What we would say is we've not seen many so far. I mean, we have had claims in which there are queries about potential claims, mainly relating to care homes or residential homes. And I can certainly see that they are likely to be the sources of claims potentially in due course. We look at, on what basis they'll proceed, look at what the Industrial Injuries Advisory Council is saying about them, causation, whether they're divisible, and what the defences might be. So, basis for COVID claims, obviously there may be employers' liability or public liability claims. In terms of employers' liability, there's going to be alleged breaches of duty by employers, particularly care providers, perhaps restaurants, entertainment providers, both common law and statutory in the case of the employer. You got to look at the employer's duties in sections 2 and 3 of the Health and Safety at Work Act 1974. Section 2 obviously deals with the duty to ensure the health, safety and welfare of employees as far as reasonably practicable. And that includes providing them with information, training, support and supervision to ensure safe systems of work are in place and implemented. So employers will have to be aware of that in relation to how they are implementing the various measures put in place for COVID. Public liability claims, well, we've got to consider whether the duty of care was owed to the potential claimant, what the scope of that duty was, and the proximity, or the reasonable foreseeability of the harm and breach of duty. And I think pursuers, particularly in them, are likely to require to prove that the guidance that, as it stood at the relevant time, wasn't followed. I think COVID claims will be treated as disease claims, therefore they're not subject to the CPAP rules, but we do have to bear in mind that a disease pre-action protocol is supposed to be coming in Scotland. Not quite sure what's happened to it at the moment, but it is supposed to be coming, and that would apply to these claims. You might be aware that the Industrial Injuries Advisory Council have obviously been considering COVID-19, and in March this year they issued a position paper on COVID-19 and occupation, and their conclusion at that time was that there was a clear association between several occupations and increased risk of death from COVID-19, but the evidence was too limited to justify prescription at that stage. But they said they were continuing to closely monitor the literature, and they've indicated that they'll recommend prescription if there's a strong enough evidence that occupational exposures cause disabling disease on the balance of probabilities. So it'll be interesting to see what happens with that. And obviously you'll appreciate that state benefits are awarded if a disease is on the list of prescribed diseases, and civil claims often follow. So we've got to look at causation, and I think, as I've said, this is likely to be difficult in many COVID cases. And I think it's probably only likely to be proved where it's clear there was no likely other source, or where potentially there are multiple positive cases in a workplace. And the but-for test will come into force, and the pursuers were required to prove the defendant's breach of duty was the likely cause of infection. So you can see that that might be quite tricky in some circumstances. However, if you get perhaps a lady who's driven to the office by a member of her family and goes nowhere else, and was sitting too close to people, not maintaining social distancing, not maintaining any measures in an office, you can see how her case may well succeed and meet the but-for test. But I think in many cases pursuers would struggle, because we've got to bear in mind that COVID-19 is obviously an airborne disease with a high prevalence of community transmission. So the pursuers have got to show that the claimed cause was the most likely of potentially a number of competing options. And I think we are likely to see expert evidence regarding transmissibility being used in some cases, certainly at least at the start. So then we've got to look at, well, what other tests might be used if the pursuers face difficulties using the but-for test. They might seek to rely on the material contribution test, and you'll appreciate that applies where there are cumulative causes for the contraction of a disease. We've got the case of McGee against National Core Board from 1972, and then Williams from 2016 dealing with that. I think pursuers might seek to rely on the material contribution test, but whether they'll succeed with that or not is another matter. I'm not sure that they will, because I think the science in COVID-19 suggests it's contracted by a single exposure and it's therefore not divisible. And if it's not divisible, then the material contribution test is arguably not engaged in COVID-19 cases. So I think that's one to look out for, but one that hopefully we should be able to prevent being used successfully by pursuers. I'm conscious of the time, so I'm trying to be swift in dealing with this. Material increase to risk test. I wonder whether it's possible the courts might take a benevolent approach to causation in COVID-19 cases, such as they did in Fairchild with meso cases. I think it would probably be a fair extension of Fairchild to apply the test out with the employer or employee relationship, but it will be interesting to see what approach that the courts do take to causation in COVID cases. So, got to have a think about what defences might be employed in COVID cases. I think compliance with guidelines is going to be very important, but care will need to be taken to ensure it's the guidelines which were in place at the particular alleged time of exposure, which are relied upon, and which are relied upon by the defenders to show that they did the right thing at the right time. Obviously, the guidance is changing all the time, and I think it's important for employers and venues in particular to be very up to date with the guidance. If guidelines are complied with, I think there'll be a good argument that there was no breach of duty to take reasonable care. I think that sector guidance from regulatory bodies will also be taken into account as to whether reasonable care has been taken in particular circumstances. And I think quite often we'll simply find ourselves putting a pursuer to proof as to the source of the infection and putting them to proof of the but-for test. I said at the start that there hadn't been a huge amount of these claims so far. I mean, we think there might be a delay in the pursuers agents raising claims while, for instance, criminal investigations are carried out regarding discharges to care homes and also pending the planned public inquiry. Claims are most likely to come, at least initially, where causation is clear or there have been multiple cases connected to a workplace. I certainly think it's likely that some fatal claims will be pursued, and it certainly wouldn't be surprising to find one or two making their way to the Supreme Court. And I think it's a case of watch this space to see what happens. We thought that we had better mention QOCS, which have obviously just recently come into force in Scotland, and see what impact they've had. On reflection, the answer is not much impact so far at all, so there's not really too much to report. There's certainly been no deluge of claims, which was potentially expected, particularly in the disease area. We thought we might see more deafness claims in particular coming forward. There's not been a deluge yet, but we wonder whether that's due to the pandemic potentially, so it may be that there is still more to come. Tenders are still being accepted. We're using some tactics to try and limit judicial expenses. Given QOCS are now in play, what we're doing in particular is writing to pursuers agents at the outset of litigation, asking for a detailed list of information, and if that's not forthcoming, seeking agreement to assist the case. And of course, if they don't agree to, and that limits expenses, if they don't agree to do that, then we can use it against them in terms of arguments about expenses in due course. So not too much to report on QOCS. I think it's a case of watch this space, and perhaps this time next year or even in 6 months, there'll be a bit more to say about the impact of QOCS on civil litigation in Scotland. I hope you found it useful, and if anyone does have any queries, please feel free to contact Jenny or I directly. Our email addresses are on the slides, and we'd be happy to answer any queries you might have. Thank you.